Everybody. Good afternoon. I hope that this is finding you all warm and hopefully at least some of you vaccinated as we move into the spring. And I'm saying it early, but I'm going to keep saying it because hopefully it'll come soon. Today we are going to talk about being a trustee of a trust and administering a trust. And as Liz said, this is being recorded. And we have a Q&A section on your screen that you can write in any questions. And to the extent that we don't answer certain questions, we're happy for you to email us with those questions and we can follow up. Some questions require a little extra information and a little more personal touch than just the overarching answers that we're giving today. Of course, none of this is meant to be legal advice, and especially if you're the trustee of a trust, as we're going to go through, you have a big responsibility and you're going to want to make sure you have your own counsel to assist you in your job as trustee of a trust. So with all my disclaimers out of the way, let's get started. So again, administering a trust, what does that mean? So I want to roll it back to what is a trust. A lot of people don't even know what we're talking about when we're talking about trusts. And there are many different types of trusts, but a trust is an entity that owns items. So for example, what we're talking about, a lot of what we're talking about today are going to be those who have trusts while they're alive that maybe they control while they're alive, but upon their death, there's someone else who takes over and is trustee to administer that trust. Now, a trust during someone's lifetime can own a house, it can own shares of a corporation, it can own an LLC, it can own regular stock, cash, mutual funds, bonds, whatever it is that an individual can own, a trust can own those assets as well. And so we're talking about this entity that owns items while you're alive or after death. And the real answer to what a trustee can and can't do, a lot of that is actually right in the trust document itself. And if you've listened to our webinars before, you've probably heard me say to stop giving your lawyer a hard time about boilerplate. When I first started as an attorney practicing in this area of the law, clients would say to me, well, there's just so much boilerplate here. And I would get embarrassed. I thought it was a dirty word and I didn't want to talk about boilerplate. And then the more experienced I got, the more and more I started seeing trusts that did not have boilerplate. And I usually saw them in the context of there being an enormous ambiguity and the trustee didn't know what their responsibilities were and the beneficiaries didn't know what their rights were. And in the end, the boilerplate is what would have made the trust less ambiguous, clear to all parties, and everybody would have been right in line with what had to be done and what the responsibilities of that trustee were. And so we like boilerplate because boilerplate is what makes a trust go. There are a lot of different reasons to do trusts. So many of our clients do trusts, revocable trusts while they're alive and put assets in them to avoid probate at their death. We've talked about this before. You avoid probate often because you have a disabled beneficiary or perhaps because you have assets or real property in multiple states and you want to avoid the will having to be probated in multiple states. And so you put everything in a trust while you're alive to make it easier to administer after death. Some create different types of trusts for tax efficiency purposes, others for asset protection purposes. And so what type of trust you're creating is really going to depend on your circumstances. But all that being said, there are certain things, and that's what we're going to go through today, that a trustee after your death is going to have to do regardless of the type of trust that you are creating. So for the purposes of this conversation, we're really talking about after death, what a trustee does to administer a trust. And most often we're talking about a trust that was a revocable trust while someone was alive, although a lot of these things refer to all different types of trusts. So a big question that I get from people is, will probate be required if I have a trust? Well, the answer is, it depends. It depends what assets are owned by the individual who died at the time of their death, and how they were owned, and if there were beneficiaries. So for example, if I have a checking account in my sole name worth let's say $60,000, and I have a home that is joint with somebody else, and I have a retirement account that has a named beneficiary, and I have another home that's in the name of a trust, well, then there will have to be probate, but the probate is only going to be for that $60,000 checking account, because all of my other assets were either owned by a trust, therefore not in my sole name, owned jointly with another person, not in my sole name, or they had a named beneficiary, like my retirement account that I referred to. And so whether or not there has to be a probate depends on what assets are owned and how they are owned at the time of the person's death. When we create trusts for individuals, we are often creating what's called a pour-over will. That's the term we use for a will that says, upon my death, if my will has to be probated, all of my assets should be poured into my trust. And so it's literally a pour over will. So you're pouring the assets into the trust, but that doesn't mean that that will, if it's going to be followed for that checking account, that will has to be probated. The executor named has to be appointed. And then that executor would pour over or give over that checking account to the trustee of the trust, who would then distribute the assets of the trust according to the terms of the trust document. And there often is the executor and the trustee, they're often named as to be the same person, but in some cases they're not the same person and there's not coordination, and they need to coordinate amongst themselves as to payment of debts and expenses and how that will be done. So who is the person to administer the trust? So we've talked about this already, it's the trustee. And some people have a trust that says who's the trustee while they're alive, and sometimes they want somebody else to be the trustee after death. I had a client who wanted her sister to be the trustee while she was alive if she became incapacitated, so that her sister could take care of her and make sure that she had everything she needed. However, upon her death, she wanted somebody else to be the trustee for the purpose of collecting and distributing the assets, because it was going to be very complicated for her sister. She had various beneficiaries. And so she actually named our law firm to be the trustee after death in order to collect the assets and distribute them. And so we served after the sister. And importantly, her sister was responsible for the trust up until the point of handover. And then after death, when it was handed over to us, then the liability and the responsibility fell on us as the after death and distribution trustees. So what are some of the first things you need to do? You know, if you had a checklist, what were the things that you need to make sure you do as the trustee of a trust? And if you've ever been the executor of a will, or you've ever learned about being the executor of a will, you're going to find that a lot of these things are the same jobs for a trustee as would fall upon the executor. So right off the bat, you're going to want to notify health insurance providers, pension, if you have a pension provider, you're going to want to notify those individuals of the person's death, or those companies of the person's death, so that final claims can be made, final payments. Sometimes with pension funds, there's a death benefit, and that death benefit might be owed to the trust. And so as trustee, you're going to want to make sure that you are figuring out if there's any funds owed from that pension to the trust. You're going to want to forward the mail from the deceased individual to yourself as trustee, so that you can see what bank statements are coming in, what bills are coming in. You can determine who the creditors are and what all of the assets are. And you're going to want to take an inventory of the personal property. This might include artwork, jewelry, clothing, furniture, the contents of a safe deposit box. You're going to want to make sure that you are aware of what all of the assets are, the estate are, right from the outset, and document that you have figured that out, so that you can make sure that when we get to the end and we talk about reporting requirements to the beneficiaries, that you have all that documented right from the start. I think that it is also very important to talk about the Schedule A of a trust. So a Schedule A on a trust document is often found after the signature page on a trust, and it is a list of the assets that the trust holds. Now, very often when we're meeting with clients to sign their trusts while they are alive and well and doing their planning, we put on the Schedule A the assets that we know are being transferred into the trust on the day that we sign the trust. That is very often just the property. So for example, if we're signing a deed, putting a property into a trust, well then that will be listed on the Schedule A. But we encourage clients to keep their own Schedule A or their own list of trust assets, because that's going to make things a lot easier on the trustee after death. So I talked about getting the mail forwarded so you could figure out when bank statements are coming in what the assets were. But wouldn't it be easy if that trustee had a Schedule A, a list that they were working off of to start to say, I know that these assets are in this trust because this is a Schedule A document that the deceased person was kind enough to leave behind for me, so I didn't have to go searching for what these assets are. Now, we can find what those assets are. We often look to past year's tax returns to see where there were accounts and where there was interest earned and taxes were paid. We look to the bank statements. We look to, we usually put in a trust that the trustee has the right to access digital assets. So often we can find through paperless in the email account if there's statements coming in, or through the regular mail if statements are coming in, to put that list together. But we really don't want to have to do that because that's how assets could get lost and not identified properly by the trustee. So again, keeping that Schedule A while you're alive is going to make things a lot easier for the person or the entity that you leave behind to administer your trust. So then the trustee is in charge of making that list and determining what all those assets are, collecting them, although they're already under the umbrella of the trust unless they're being poured over by a will. Another way that assets often make their way into a trust could be by beneficiary designation. So for example, I recently spoke with a client who had a brokerage account, and for various reasons, they did not want the brokerage account to be owned by the trust while they were alive, but they were very happy to name the trust as beneficiary or transfer on death beneficiary of that brokerage account upon their death. So all the assets would be under the trustee's control, avoid probate, and be distributed according to their plan. But they didn't want to change ownership while they were alive. So it's going to be important, in addition to the Schedule A, to keep good recording and good list while you're alive of what assets will be payable to the trust upon your death. So then we look to the trust document as to how the trustee has to manage trust assets, because it's not just as simple as look at the assets, what are they, pay them out to the beneficiaries. There's often a time period, and every trust is different based on how complicated the assets are and how complicated the terms are. But it could be 6 months, a year, or even longer before the assets of the trust are fully distributed. And so the person administering the trust, that trustee, may be in charge of the trust for several years. And so the trustee needs to know what their obligations are during that time. And this is where the counsel of an attorney is going to be incredibly important. And not just so that the beneficiaries get what they're due, but so that the trustee keeps themselves safe from any of the common mistakes and pitfalls that we see, and opens themselves up to personal liability. Because what's the point of being a trustee if you're just constantly getting yourself in trouble because you're not doing what you're supposed to be doing? And a lot of people run into that problem when they don't have proper advice. So you really want to make sure that you're being advised as to your responsibilities as trustee, and also what your rights are and what liberties you can take, what you can reimburse yourself for, etc. In addition to having the lawyer advise you, you're going to want to make sure you have an accountant, and you're going to want to make sure you have an accountant that's experienced in dealing with trusts. And we're going to talk about the tax implications of having a trust, and that's going to become very evident as to why you need that. And you also want to make sure that if there are difficult financial assets in the trust, there's stocks, there's bonds, there's mutual funds, whatever the investments are, you want to make sure that you have a financial advisor who can review what the trust assets are and advise you as trustee during this time period where you're responsible for what may in the end be other people's money, that you are aware of the pros and cons of the investments as they're written and how to deal with them. You're also going to want to speak to the beneficiaries, and you're going to want to know what the beneficiaries are thinking. And we'll talk about the distribution of assets in a little bit, but it's going to be important to keep in line with the beneficiaries, especially if you have more complicated assets than just straight cash in the trust. An important thing to find out when you're trustee is if the trust owns real property, or if the trust owns a co-op, for example. Is there a direction for you to sell that property, or do the beneficiaries want you to sell that property? Because if so, then it's going to be your responsibility to make it suitable for showing, and that could include clean out and inventorying what's inside of the apartment and putting it in storage. It could include staging the apartment or the home for sale, and then hiring a realtor, and then moving forward with sale and closing, and then just taking in those assets from the closing and continuing with those as additional assets of the trust. And so you're going to want to know if that is something that you are responsible for taking care of. Also during this time, you're responsible for the upkeep of the property. So it's very important. You want to make sure, is there homeowner's insurance on the home? Because you're going to have a hard time getting title insurance and getting the closing done on a sale if you don't have insurance on that property. We have a client who was the fiduciary on an estate, and there was an apartment, and the apartment had damage not caused by the fiduciary themselves. The apartment was empty, but caused by a neighbor. And that is a responsibility that this fiduciary had to deal with. And luckily, the homeowner's policy was intact, and therefore that was able to be taken care of in a much easier manner than if there was not any insurance on the property. And so that is the trustee's responsibility, is to manage the properties and to make sure that the proper insurances are in place. This could include paying the maintenance at a co-op. It could include making sure the lawn is being mowed to make it look nice for sale if it's a home. Whatever has to be done, snow removal to make sure there isn't damage, etc. We just had a big snow here, and if the house is sitting vacant, were the pipes going to freeze? Is the heat on? Is somebody paying for the oil so that the heat stays on, or the propane, or whatever it is that heats the house? These are things that a trustee has to think about, because again, they're responsible for this property. Another thing that the trustee has to think about is what to do with the assets in the trust, and making sure that all transactions that they do are on the up and up, for lack of a legal term, and are in our arm's length transfers. So for example, if you are going to have someone come in to check the pipes, maybe in your own home, you would have paid a plumber $300 cash, and he would have come in and checked it, and you would have dealt with it that way. But when you have to account to other people, because this isn't your money as trustee of the trust, you need to have proper receipts in place, and you need to make sure that everything is being done, so that if this is, does a contractor coming in have insurance? Because if something goes wrong, you want that contractor to be able to pay for any issues, again, because you're responsible for the property of others when you are a trustee. If you have somebody, a family member, who maybe comes and says, I want to buy a house, and I know this money is sitting in grandma's trust waiting to be distributed, since grandma died a few months ago. And, mom, you're the trustee of grandma's trust and I want to buy a house. Can you loan the money to me? Well, that has to be an arm's length transfer. And I would say that the quick answer would be that's probably a bad idea. But if you are going to go forward with something like that, you're definitely going to want to make sure that the loan documents are compliant with any laws that they need to be compliant with. And again, that nobody's going to come back and say that this trustee did anything improper with the trust. Receipts. Make sure that not only do you keep receipts for anything, but to save yourself the headache later, you should keep a log as you're going. So if in February of 2021, you paid the homeowners, that should have a line and it should be written out in the log. You can do it online in something like a Microsoft Excel, or you can do it on your own on a piece of paper, but I would keep a contemporaneous log so you're not scrambling later to figure out what funds were spent as trustee of the trust. You don't want to commingle trust funds, so you don't want to mix your money with trust money. Any trust money should be in a separated, segregated trust account, and that account should be used to pay trust expenses. If there's something that you have to pay as trustee out of your own pocket individually, then you want to have a receipt for that and a penny for penny reimbursement to yourself. So it shows that you're being exactly reimbursed for what you paid out for from the trust. So there's no ambiguity down the line and no question from the beneficiaries that you were just handling the trust assets properly. You are going to want to make sure that you're using, again, a financial advisor to deal with certain financial assets, an attorney, an accountant. You want to put your team together. You don't need to know all the ins and outs of all of these rules, but what you do need to know is what you don't know and what there are professionals out there to assist you with. And again, you're holding on to other people's money and you don't want to open yourself up to liability. We talk about having a financial advisor. Well, part of the reason is because what if there are stocks owned by the trust? Well, what if it is stock, and we've seen this a lot. I have clients who come in and they've got a paper stock that was the original stock certificate that was purchased, and it was in a company that they worked in for 50 years, and it's very important to them. And when they die, they want their children to have that stock, not the monetary value of that stock, but that stock. And when they die, the children, who may or may not be the trustees themselves, but are certainly beneficiaries, say, well, you know what, my parent really loved that company and really wanted us to have that stock, and we want to hold that stock. And so as trustee, if you're meeting with the beneficiaries and you're talking to the advisors, you can be aware of, should you just be giving over that stock certificate in kind, meaning are you just giving the stock to the individual? Or if that whole story I told about the company being really important to mom or dad is not the case, well, do you need to, as trustee, cash in that stock and cash out and make it liquid so that you're not responsible if there's a dip in the stock market? So, as a trustee of a trust, you are a fiduciary, which is a heightened level of responsibility to the trust beneficiaries and to the estate of the person who's passed away. And while you're not necessarily responsible to be an aggressive earner and to make money for the trust, you can be personally held responsible if there are big losses. And so a lot of times, if there's a big stock portfolio, we'll meet with the trustee, with the financial advisor, get a sense from the beneficiaries, and we'll be saying, in this case, you should probably be cashing out of all of this, and you should be liquidating because you don't want the responsibility that the market is volatile right now and it could drop. And we saw this with the start of the pandemic a lot, and throughout this past year, that if somebody died, if all of a sudden things were going well and then the market dropped, is the trustee now in a position where they didn't do anything and they should have? And so you want to get the advice on that. It's very important. So now we've talked about all the assets. So what's next? So next is the trustee. They know what's in the trust. They have the liquidity. They have the money. Well, now they're going to have to pay out for all sorts of things. They've got to pay the debts of the estate. So they find out what those bills are, like we talked about with checking the mail. You would call, you would cancel the credit cards. You want to report the death of the individual to the 3 major credit bureaus, Equifax, Experian, and TransUnion. You want to prevent fraud, prevent somebody from pretending that they are the deceased person and trying to get something on their credit. You go through what the debts are and you determine what is the priority of what has to be paid first, and then paying off debts that make sense. Sometimes we see debts come in from a nursing home or a rehab facility or a hospital. And when we look at them, we realize that nobody ever tried to bill Medicare or nobody billed the supplemental insurance. And so sometimes you have to provide that information so that that claim can be put in, so that's less money coming out of the trust. And so as trustee, you're responsible for taking care of that. Now, taxes. So we talked about having an accountant. Why? Because the taxes of a trust can get very complicated. I'm going to try and simplify them for you here. So as trustee, you need to make sure that you're paying filing for the final income tax year that the deceased person was alive. So if somebody died in the year of 2020, you need to be filing in 2021 for their final year's taxes. And if there's anything owed, there might be a refund due to the estate, in which case you want to get that and claim that as trustee. You will then also, as trustee, need to file income taxes to the extent that you are trustee of a trust that's earning income. So let's say it takes a few years to actually collect all the assets, and maybe there's some litigation over trust terms and who's the beneficiaries. And as trustee, you're managing the assets that whole time. Perhaps there are earnings and there is income being generated by that trust. Well, then that trust has to pay income taxes. A trust pays in the highest tax bracket. Trusts and estates both pay at the highest tax bracket, except for to the extent that if that income is paid out to a beneficiary, then the beneficiary can claim that income on their tax returns. And so as trustee, especially again of these complicated estates that take a long time to administer and there's a lot of different assets, you want to make sure you're doing the proper reporting requirements. That's income taxes. Then we have to deal with estate taxes. So I'm going to tell you a little bit about the numbers for estate taxes right now. So in New York State in 2021, for those who die in 2021, they have a $5.93 million exemption from estate taxes. So if you die with $5.93 million or less, there are $0 owed in estate taxes. But unfortunately, we have what's called a cliff, or what we call a cliff. So you can think of it this way, I think like a roller coaster. You slowly go up, no tax, no tax, no tax. And once you fall over the top, you fall down to the bottom fast and you pay taxes from $1. So let me put this into some dollars for you, just so you can see the effect of this. So $5.93 million, no tax. If you're $100 over that, so if you are at $5,930,100, you only owe $227 in tax. Not so bad. You can usually handle that, especially on an almost $6 million estate. But if you hit the peak of that cliff, which is at 105% of the exemption level, and that equals $6,226,500. So once you hit that cliff, you owe $538,992 in tax. So I'm just going to slow down and say it again. $227 if you're just over the exemption amount. And if you go over that 105% cliff, you're paying almost $540,000 in tax. That is a huge difference. Now, we're not going to get into it today, but if you think you're close to that cliff, you should be thinking about seeing an attorney to talk about what you can do to avoid going over that cliff, especially if you're hovering right on the edge. So that's an important thing to look at. That's a big difference. And those taxes are due 9 months from date of death. And so if you're a trustee of a trust, you need to be thinking about liquidity. So if I have these assets in a trust, how am I going to pay these taxes so that I don't start to incur penalties for a delay? And so this is a really important job of a trustee. And this is why you're really going to want to get a handle on what those trust assets are right away, because time is literally ticking when you have a taxable estate like this. Those are the New York State rules. Federally, right now, you have an $11.7 million exemption. But this includes life and death gifts. And I'm going to get into that in a second. The $11.7 million exclusion is set, according to the current law, to sunset at the end of 2025, meaning that if you die right now under the current law until December 31st, 2025, that's the exemption. Once we hit 2026, the exemption is going to drop back down, and it will probably be somewhere about 6 million based on inflation, probably pretty similar to what the New York State level is. So now you're at 11.7 million, you have a lot more wiggle room, especially because if you have a spouse, they also have 11.7 million. But it's life and death. So New York State does not have a gift tax. And if you give away $5 million and you survive that gift by 3 years, New York State is never taxing you on the fact that you gave away $5 million. However, the federal government would have required that $5 million gift be, that a gift tax return be filed to show that $5 million was given away. It's a placeholder against your exemption. So if you're talking about the job of a trustee who's managing a trust and administering a trust after death, they don't need to only know what's left in the estate when someone dies, but they need to know what exemption was already used up. So what exemption was used by lifetime gifting? Were gift tax returns filed? A trustee needs to know that. A trustee needs to know, is there unused exemption from a spouse that predeceased that can still be used? So if somebody dies and they have an $11.7 million federal exemption, but when their spouse died 5 years ago, they only died with $2 million in their name. If the proper filings were done, a proper estate tax filing was done, there could be about, depending on what the exemption was at the year that spouse died, that's many millions of dollars extra in exemption that could be used when the second spouse dies. And so the trustee needs to know what happened in the past so that they can determine if that person has a taxable estate going forward. So again, that's a big responsibility on the trustee because they need to know what happened in the past. And so if you're someone who's leaving behind a trust with a trustee to manage it, the best that you can do for them is to organize all of this and to have your tax advisors and your financial advisors and your legal advisors have as much of this information as possible so that your trustee can step into your shoes and start to handle things as seamlessly as possible. Sorry, I had a little electronics issue, but I'm back. Okay, so if you then are at the point where a trustee is now going to account, so maybe they've sold the property they have to sell, they've collected the money, they've decided what to do with the stocks, and they're trying to figure out distribution now. Now, a trustee is usually told, give this percentage to this person, a certain percentage to a charity, a specific dollar amount to another person. And so in the end, that's how they're distributing the assets. But what if the assets isn't just a straight bank account with cash? We already talked about that stock. What if there's that, I see it sometimes with GE stock or one of these older companies, and somebody wants that specific stock, then the trustee has to figure out if they have the ability to give that stock to one person and then equal out that gift to another with cash. And the trustee has to determine if the terms of the document allows them to do that. Let's say, for example, you have two beneficiaries, 50-50, and there's a condo worth $300,000 and there is an account worth $300,000. Well, does the trust allow for you to give one person the condo and the other person the account? If the right language isn't in that trust, then it's looked at as half of the condo goes to each of the 50% beneficiaries, half of the account goes to each of the 50% beneficiaries, and then there has to be a sale of half of the condo to the person who really just wanted the money, and then there's a transfer tax that has to be paid on that. And so again, these are the types of things that you don't need to know the ins and outs and the details, but you need to make sure that you have the proper advisors that can review the documents that you're working with and explain to you exactly how you must behave as trustee to make sure that you're properly filing all sorts of tax documents and paying any taxes that are owed, and also not opening yourself up to liability with the trustees, with the beneficiaries. So when you get to the point of wanting to distribute, you have to do an accounting. Now, some trusts require, the terms of the document will require a formal or a judicial accounting. Many do not. Many are trying to avoid the courts being involved, and so there can be an informal accounting. Just how informal that accounting can be is going to depend on who the beneficiaries are, what their relationship is with the trustee. Do they like them? Do they not like them? Are they suspicious of the behavior of the trustee? Are there disabled beneficiaries? Are there charities as beneficiaries? Because then we're often involving the Attorney General, who looks over the bequest, the residuary distributions to charities. You can't account to yourself. We recently had a case where there was an individual who was the trustee of a family member's trust, and also the family member's trust said upon their death, the assets went to their child who was disabled in a trust. And the trustee of dad's trust is the same as the trustee of child's trust. Now, you can't account to yourself, so there's going to have to be a judicial accounting in that case, because the disabled beneficiary is going to need somebody to be checking over to make sure that the trustee is doing their job. And so whether or not the accounting has to be formal or informal, it's going to depend on a lot of different factors. Also, just how informal is going to matter. I've had cases where there's one trust bank account, all the assets were in that bank account, the beneficiaries got along, there was no issues to be concerned with, it was fairly simple. And so the accounting could just consist of, if they were trustee for 16 months, giving the 16 months of bank statements, seeing what went in, seeing what went out, asking a few questions, and that's it. Whereas in other cases, if it's much more complicated, then we really need to start using QuickBooks or some other more difficult or more challenging, I should say, accounting method to really show what went in, what went out, and what the trustee did. Because the whole point of this is that the trustee needs to account so that the beneficiaries can sign a receipt and release that says, yes, I reviewed the accounting that was given to me. I have no concerns with it. I am going to release this trustee from any liability in exchange for receiving my distribution. And we would tell a trustee that you really should hold back on distributing any assets until all of the beneficiaries have signed off. Because if one is going to have a problem and it's going to create an issue, the trustee is going to make sure that they are covered on all other fronts, that they have assets in the trust to handle the litigation if necessary, and to move forward accordingly. And so you're going to want to make sure that some type of accounting is giving over. Otherwise, that receipt and release has no meaning because they can't say that they reviewed anything that they approve. We usually also have the distributions happen and then have some assets be held back for final distribution to make sure that the final year's tax returns can be paid, any final legal expenses or other expenses of the estate before the assets are paid out in full to the beneficiaries. The last thing I want to discuss is trustee compensation. Trustee compensation is not as straightforward as many believe, but I'll discuss the percentages a little bit and then say that in general, it's a calculation that is going to be determined by the attorney handling the matter for the trustee based on the type of assets, what's income, what's principal, and that all makes a difference in how they're paid out. But in general, it's 1% of the principal that's paid out during the lifetime of the trust. And then there are annual commissions. And just as an example, it's a sliding scale. For the first $400,000 in the trust, it would be $4,200 a year in annual commissions. Again, some trustees are serving for a very short period of time, whereas other trustees, it's more complicated and they're serving for several years. And then the way the calculation goes, it's approximately $6,900 a year for trustee commissions on $1 million estate. And it gets larger and larger depending on the size of the estate. So that is the content today. I'm going to take some questions. I see there's some down there. But in general, I hope that your main takeaways here are that being a trustee is a big job. And if you have the proper assistance, the proper advisors, financial, tax, legal, it's a job that many people can do. You just really need to make sure that you're taking it seriously because you have an important responsibility to the person who's passed away, who's left you in charge, as well as to the beneficiaries that they're leaving behind.
Thank you, Britt. I have a couple questions here. The first one is, what is a boilerplate?
Oh, that's a good question. So boilerplate is, a lot of people, if you look at a lease or a contract, there are those set terms that are in every lease and every contract. And a lot of times it's the definition of explaining what a word or a term in the document meant. And it's the certain laws that go into it. And a lot of people, when they're reviewing documents such as contracts, leases, trusts, wills, they say this is boilerplate language, meaning it's not really tailored to the individual. And so I brought it up to point out the importance of having that language in a document to make it a valid, strong document.
Thank you. Next question. How many months should I plan for to look after the house financially until it sells?
Yeah, so it's a hard one to say. As many of you know, our practice spans from New York City, where I'm sitting today, and then we also have two offices out in Suffolk County, as far out as West Hampton. We have a lot of clients out on the East End. And the difference in sale time right now, especially, is incredible. I mean, I have some clients who are putting their properties on the market on the East End, and within a day they're getting 20 offers and accepting an offer, and they can close very quickly. Now, very quickly in New York is still usually a few months. But then there's others that put a property on the market, and depending on how it's priced and who the realtor is that you get and the advice that you get and how aggressive you want to be with selling it, it could take a very long time to sell a property. And so that's a hard question to answer. It just really depends on how long it takes the property to sell. But certainly if somebody is the trustee of a trust, and they own the trust owns a property, and the only other asset is about $20,000, let's say, Well, you're probably going to want to aggressively sell that property so that you don't run out of the $20,000 prior to sale. Whereas if there is a lot more money, it might make sense to price the property a little differently in order to get a larger sale price. And again, this is the type of thing that is going to depend on where the property is, what type of market, what are the other assets in the trust, who are the beneficiaries, and they're going to be decisions that are made with advisors.
Thank you so much. I don't have any additional questions. I did see that someone had their hand raised. If you are able to type in a question in the Q&A, if you're unable to figure that out, like Britt said when we started the webinar, please feel free to send your questions to us at info@burnerlaw.com. We'd be happy to answer those. I do see a couple questions popping up. I'll start here. I am the trustee of each the husband and wife's trust. My question is more specific to these individuals. May I reach out to you separately? Like I said, info@burnerlaw.com would be a great platform to send those questions to us. The next question here is, what's the difference between a revocable trust and an irrevocable trust?
Yes, so those are very broad titles. So the real difference is, just as it says, a revocable trust can be revoked, amended, restated, changed in any way by the creator of the trust during their lifetime, whereas an irrevocable trust will have some restrictions. Exactly what the restrictions are going to be are going to depend on exactly how the trust is written. But that's the general difference between the two.
Thank you. Next question. Mom has a trust. Her house is now in the name of the 5 children. Does expenses for the house get split between the 5, or does trustee pay and then get reimbursed?
So it's going to depend on a few more details of this, and I think this is the same person who asked if they could ask specific questions. So they're going to need different advice probably, but it's going to depend on the exact title of the home and exactly what the trust document says about how the asset should be dealt with if it's prior to sale.
Thank you, Britt. Does every trust have a pour over?
Every trust does not have a pour over. So we very often will, when we draft a trust with the client, in many cases, we will also have them have a pour over will that they will sign at the same time as signing the trust. But not every trust does have a pour over will. You would have to actually sign a separate will document to have that.
Thank you. Is there a checklist printed or a chronological order of what to do when someone dies?
So we don't have a set list that we have. We've written articles, and certainly on our website, you can go and take a look at the articles in this category under, trust and estate administration. But it's going to be different in every case because everybody has different creditors, different assets. And so it's going to be different, but most often we can give somebody somewhat of a path forward after we meet with them and we know exactly what they're dealing with.
Thank you.
I think there was a second question on that one.
Let's see. If my mom and I jointly own a savings account not in her trust, I am the trustee, what do I need to do with those bank accounts?
So I assume that this person is asking about a bank account that is ITF in trust for and then has this individual's name. That's actually different than a trust that we're talking about here. That is actually the equivalent of being the beneficiary on the account. So if it's mom, ITF, daughter, then upon mom's death, that account belongs to daughter. She should go to the bank with the death certificate and collect those assets. Now, whether or not those assets are to be distributed with other family members or to charities, legally that account belongs to daughter. However, the daughter may decide to follow some wishes that mom had informally stated, and that's between them.
She clarified and said, no, we jointly own the account, not ITF.
Okay, so same thing. So if you have two owners on an account, you own it jointly, then upon the death of one owner, the other owner is the only remaining one, and the assets belong to that person. A death certificate should be given to the bank.
Thank you. Next question. How is property sale prices determined to make sure if it is accurate and not just undervalued for quick sale, which could make problems between beneficiaries, home sale, collectibles, etc.?
So usually, if you're looking to do your due diligence, any home price could be based on comps, other homes that have sold of similar age, of similar condition in the neighborhood, similar size, in the surrounding areas. And so you can show that those assets were sold. And obviously, if you have something like the pandemic hit and prices dropped in the area and nothing was moving on the market, then that could go into it as well. You could have multiple realtors give you their opinion on how they would sell it. And in certain cases, but you might not always want this, there's a lot that goes into the tactical decision of whether to do this. You might just want to get an appraisal of a formal appraisal of the property and show that an independent appraiser appraised it at a certain value, and then go from there. So it's going to depend on the market and on the individual property. But I would say getting comps in the area to show what has recently sold of that same caliber is a really good way to do that. Thank you so much, everyone, for joining us. I hope you enjoyed it, and have a wonderful day, and we'll see you again in a few weeks.